Good morning. Can you hear me? Fedria, can you hear me? You're on mute if you can. Your mic is disabled. Okay, let's see. Okay, let's try now.
Ah,
There?
hooray! You can hear me. Yay! Excellent, excellent. Okay, good.
Hi. How
How
are
are you
you?
doing?
I'm good.
I I am well. I'm ready for this presentation. I'm excited. I
Excellent.
think speaking with caseworkers is really helpful for our clients because
Yeah,
oftentimes some of our clients can't identify what's happening to them, but
yeah.
maybe caseworkers can. So I'm excited. Yeah.
Excellent. Do you need to do any screen sharing? Let's make
Yeah.
sure you can do
So
that first.
let's see. Uh, so you're the organizer and the presenter, so it's saying that only you can
Okay,
share.
let's see, make a
But if you,
presenter. Okay, let me go that. And now let's see if that lets you.
and it should pop up here in just a minute. This is the one that I want.
Tell me how to pronounce your last name. I want to say it right this time.
So it is Marion.
Marianne, got it. So
Yeah,
what I
J Marion.
usually do is do like a just a quick welcome and plug for Away Home for Tulsa
Yeah.
membership, and those meetings are open, and then I'll hand it over to you, Marianne, right?
Marion. Yes.
Marianne.
Yeah.
Got it. I want to say it right. Okay,
Yeah.
excellent. Looks like you're all set. So what, we still got about 5 minutes. So I'll probably wait. There's a couple people in the lobby, which is great,
Yeah.
but I'll
That
kind of
sounds
wait. I
great.
think we had, I don't even know how many people ended up registering. And the last time I saw it was about 15, which is great because I think small
Yeah.
groups are really good for questions and like getting
Absolutely.
into
Um,
detail.
And this presentation runs about 45, 50 minutes.
Okay,
Is that good for enough time for questions?
that's perfect.
If they're okay, perfect.
And
Yeah.
do you want me, if I see questions in the chat, do you want me to stop you or do you want to just wait till the end and kind of go through those?
It's sometimes better to wait until the end because sometimes
Yeah,
people
because they
ask a
might get them
really
answered.
specific question that's like gonna interrupt the flow. So it's sometimes good to
Got
wait.
it.
But yeah, that'll be what we do. I have another question. So we typically, as we do presentations, we have to report our like numbers and names back
Sure.
to like our grant provider, which is like HUD. Is there a way I could get a copy of
Yeah.
who shows up today?
Yeah, so what I'll do as I don't know exactly what reports, but I think at the end, because I saw a link on the webinars for attendance reports and that sort of thing. I
Yeah,
don't know if it'll tell me organization,
that's okay.
but what I
If you
can
don't have,
do
yeah,
is during the intro, see if people would put that in the chat.
that'd be perfect. Yeah,
So I'll do that. Um, yeah,
awesome.
just trying to see if there are any other settings that I need to change. I don't think so, but I'll just, this is only our second webinar one that we've done, so I'm still learning like what
Yeah,
the differences are from webinar to just like a regular meeting. So we're kind of playing around with some
yeah.
things.
Are you finding that you get more attendees with the webinar form or
um, This is only our second one. So the first one
yeah,
we did was for our state of homelessness, and we had a lot of attendance, but it was a really big topic.
true.
Because we were going over all of the pit count data. So you're
Yeah.
the first one for kind of the smaller, more intimate conversations that are more around training topics.
Yeah, very cool. Well, I am somewhat unfamiliar with A Long Way Home, but I hope to learn a little bit more about what you guys are doing.
Yeah.
Yeah.
Well, and so you're probably familiar with Landlord Tenant Resource Center, that
Yes,
group. So Housing
exactly.
Solutions is the lead agency for Away Home for Tulsa. A Long Way Home is a great book, but We're Away from Tulsa.
I thought it sounded familiar, but yeah,
It's a
yeah, yeah,
fabulous book.
yeah. Long Way
We're Away
Home,
from
I
Tulsa,
think.
so that's the group that comes and meets together about all things housing and homelessness in Tulsa. Okay.
Yeah. Do you currently have a legal aid person who goes to these meetings?
Um, we used to. Who used to come? Sarah Cherry,
Okay, so Sarah Cherry goes. Okay, yes.
but she's not coming
Yeah.
anymore. So we need someone
Yeah.
to be filling that spot. That's one of the things I'm kind of working on is figuring out who is the current representative. So I'm going to work on that more in June and figure out who that
Yeah.
person should be for legal aid.
Well, I can tell you that we have a really good housing team here, and so if that is a question, I can send you. There's a housing director here at the Tulsa County office. His name is
Oh
Eric
yeah.
Hallett. Yeah, he might
Oh
be the
yeah, I
best
know
person
Eric.
to. Yeah,
He's doing the presentation next week.
exactly. So you might mention that to him. That might be
Yeah,
good
I need to
news.
find out. Is Sarah still with legal aid?
She is, yeah, but she's the
Okay.
executive. Sorry, she is the managing attorney here,
Got
and
it.
so yeah. So maybe I don't know what her schedule is like, but
Yeah,
yeah,
I
maybe
need to
check
reach
with
out.
her.
That's one of the things on my list is just kind of making sure I have the main contact and the right people.
Absolutely.
And once we get started, I'll also record that.
Mhm.
That way I can send that to you too if you need a file of it
Yeah, that
for
might be
all your
helpful.
HUD stuff too.
That'd be great.
People are usually a few minutes after 10. So I'm going to start letting the people in right now who are in the lobby. It's just two right
Yeah,
now. And
sounds
then
good.
we'll just kind of get started, maybe like 10:05, see if a few more people log in.
Sounds great.
Good morning, everyone. We are just getting started. So I'm going to just kind of monitor the waiting room as people get logged in, and we'll start in 4 or 5 minutes. right, good morning, everyone. Thank you so much for coming today. We've got a small group, so we'll have lots of time for questions at the end, which I think is kind of nice. My name's Erin Velez. I am with Housing Solutions, and Housing Solutions is the lead agency for the Tulsa Continuum of Care for Housing and Homelessness here in Tulsa, called Away Home for Tulsa. That's an open organization for anyone who is working in the field of housing and homelessness. So we'd love for you to join us at those monthly meetings. They are the the second Tuesday of every month. And all that information is on our website, housingsolutionsTulsa.org. I want to thank Badria Marian for presenting about the Fair Housing Act for us. Badria is with Legal Aid, and I'm going to turn it over to let her talk about all of things housing or with Fair Housing Act. And as we're getting started, if you could in the chat, just go ahead and put your name, your pronouns, and your organization. That would be great so that we can keep a record of that. And I'm also going to start a recording so that we can share this with people afterwards. Let me get that done. Oh, it's already recording. Excellent. All right, we're good to go.
Great. Thank you so much, Erin, for that introduction. As Erin said, hi, my name is Badria Marian. I am a staff attorney here with Legal Aid. I work specifically and only in fair housing, which I've been doing since August through a grant from HUD. I am focused in my work not only on the Fair Housing Act, but also on people who've been impacted by COVID. So that's kind of the intersection of the client base that I support. And so that is also how I'm able to do my work and how I'm able to present to you today. So actually, HUD is a sponsor of my work, and while they sponsor my work and they fund us, they are not responsible for this presentation, the content of this presentation, and the words used, and the accuracy of the statement. So that's on me and on Legal Aid. So just kind of a heads up with that disclaimer. And so I wanted to talk about the Fair Housing Act. Generally, what does it look like to have a Fair Housing Act be in play in 2023? This is a law that was signed by President Lyndon B. Johnson in 1968. It was coming out of that civil rights era legislation, attempting to equalize housing opportunities for everybody. Like that was the goal of the law. And for a law written in 1968, passed at that time, it is still so very much so relevant to present day, and it has an impressive breadth as to how it is able to apply in modern day times. I would say more than a lot of laws. Yeah, and so it is very broad as to what it will apply to. We're talking about housing in a very broad context. It's like when you're renting a dwelling, when you are trying to buy a dwelling, you're trying to sell a dwelling, you're trying to get a dwelling appraised, maybe you're applying for a home loan. The amount of different ways it could be implicated is just impressive. And so I really hope that you're able to take something away from this presentation about that, and I know you're able to maybe support your clients with some of the things that we're about to talk about. So I would, one second. So I view the Fair Housing Act in terms of, from the perspective of like somebody whose maybe rights have been violated in the form of a sort of equation. I call it my fair housing enforcement equation. And so I hope to tell you a bit about, what it means to bring a fair housing violation and how you can kind of map the parts of that, right? So first and foremost, you have to have an aggrieved person who is in a protected category, who has faced unlawful conduct with their dwelling or potential dwelling under the Fair Housing Act. And that's kind of the basic equation for getting a Fair Housing Act claim, right? So first question first, what is an aggrieved person? An aggrieved person is somebody who has been injured by a Fair Housing Act violation, or they believe they will be injured by it. So that injury is kind of imminent. They kind of see it about to happen, but it has yet to happen. So maybe somebody has been filed for in an eviction context, right? Or they're going to be non-renewed and they kind of know it's going to happen, right? So about to be aggrieved, or they are presently aggrieved. And I'm going to turn in terms of dwelling. So when we talk about dwelling, there has to be some sort of housing that is concerning this equation, right? That could be an apartment complex. That could be a house, single family house. That could be it could be really anything in which you have an intent to return back to, right? That's sort of the general like rule of thumb. There's some other factors, but it's one of the main factors. But legally defined in the Fair Housing Act, it is any building, structure, or portion thereof which is occupied as or designed or intended to be for occupancy as a residence by one or more families. This would also include vacant land. So we see some clients, they don't rent the mobile home, right? Maybe they're renting like the land underneath the mobile home. That would also apply in this situation, and that is available for sale or lease or for the construction of our location. Yeah. Um, yeah, and so one of our our next kind of a part of the equation is our protected categories, and this section is very, very, very important because without a protected category and without your protected category being the motivation for the discriminatory act, you don't have a fair housing claim. And so when we talk about protected categories, we mean membership on the basis of race, which as it sounds, on the basis of color, which is the color of your skin, kind of in comparison to another person. Uh, we will also talk about sex, which will include gender identity and sexual orientation. The Biden administration really affirmed this in an executive action from 2021. So that's how we get that. It's kind of been broadened over time. And then we have national origin, which is generally where a person is from. However, this will also include people who are perceived to be from somewhere else. So maybe you just look like you're from somewhere else. Maybe your heritage, your family heritage is that a couple generations back, your grandparents are from a certain country. This category is going to be implicated. So regardless of whether like U.S. citizen or not. And then we have religion, which is as it sounds, but also will include a perceived component. So if someone believes you're something else and that is why they're mistreating you, that will be in play. And we have familial status, which most people are kind of unaware of what that is. This is coming out of the 1988 amendment of the Fair Housing Act, specifically alongside disability. But familial status is when you have a child in the home that you are lawfully allowed to have. So you have a child that's your child, or you adopted a child, you have shared custody of a child, you have a guardianship over a child, or even pregnancy as well. And if you're being treated differently as a result of having that child in your home, right? And then the last category we have is disability, which will include a lot. There's some extra protections for disability that I'm going to get into in just a little bit because it deserves a lot of special attention. And so kind of pin note that, and we will come back to it in a moment. Yeah, and so we talked about this a little bit earlier, but I just wanted to kind of cover like who is accountable for the Fair Housing Act. Well, I like to think everybody, which is true in some senses, but specifically if we're wanting to kind of conceptualize who it is, it's realtors, it's sellers, it's brokers, it's mortgage lenders, it's advertising agents, both the person publishing the ad and the person who is wanting the ad to be published. It's homeowners associations, it's housing authorities, it's property companies, property managers, landlords, realtors, and other agents of a landlord, as well as property companies. So it is really an infinite list, it seems, of people who can be, violating the Fair Housing Act potentially. So it's just kind of good to be aware of that. And also, there is a section we'll talk about later in which even like your neighbor could be accountable for the Fair Housing Act, even if they don't own any property at all. And so just kind of keep that in mind as we go along. Okay. And so I talked with you a bit about the protected categories, and we know that we have to have those. So our aggrieved person has to be a member of a protected category, right? And there are some things that they are in and of themselves not a protected category, but they should kind of send out certain feelers of this might be part of a bad conduct or part of a bad effect on a protected category. So there are two theories of discrimination that we have in sort of civil rights theory, but also in this like fair housing component. One is called disparate treatment. And it is when you, as a member of one of these protected categories, is being treated differently than another person, right, who is not a member of that protected category. And the other type of, and that is the most common, like most fair housing claims are coming out of that disparate treatment theory. However, there is a newer theory in the fair housing context that's been recognized called disparate impact theory. And it's when there is no intentional mistreatment of someone based on the protected category. However, there is a negative impact, right, on certain members of protected categories. And so some examples of that are if there's a neutral, so basically there has to be like a neutral policy in place that is, it has no discriminatory intent, but the effect is it's denying housing to certain people. And so this is where these different items come into play. So criminal records, you know, inherently it's not associated with a protected category, but it can be used in a way to deny housing to people where maybe statistically more people of brown and black people are impacted, right, by the way those criminal records are used. So just kind of be cautious as you're working with your clients and with your case, your clients, when you see this happen. So if someone's asking for arrest records from many years ago or something, and that seems to be a policy that they have in play, be aware if it's affecting multiple people who might look alike, and just kind of be mindful if they're using arrest records versus criminal records and kind of how that's being done. And then also challenges to the source of income. That comes up as well. This is actually enshrined in Oklahoma law. But basically, if you're able to afford rent and you're able to verify your source of income, but the landlord's refusing to accept your income, that can be refused. That can be discriminatory under both Oklahoma and the Fair Housing Act if it is related to a protected class, right? So the crux of all of this we're talking about today is that this discriminatory conduct is occurring because of your protected class membership. And so it can be, I mean, people refuse to accept income all the time. We see it all the time. However, it's not often always related to their protected category. So you want to make sure that connection is kind of fine-tuned. And there are some categories where I can see it coming up. So for instance, like child support, maybe someone's weird about accepting child support, but you have this child support because you have a child that you have to take care of, and there's some sort of discrimination happening because you have that child. That might be a situation in which that comes up. So just kind of be aware of that. Another way would be if you receive Social Security disability benefits and somebody is not accepting that, and that's a rule they have, and maybe they're saying, well, we don't accept this benefits ever. Well, if they never accept Social Security benefits, what's the outcome? The outcome is a number of disabled people are now not having access to housing, right? And so this might be a situation in which this comes up. And then we have sometimes high credit score request can cause concerns. Yeah. So now we're going back to disability. We're going to highlight it. What is a disability? A disability can be kind of one of three things. It can be a physical or mental impairment, which substantially limits one or more major life activities. When we talk about major life activities, that is really, it could be anything that you have to do regularly as a person to sort of live. So walking, breathing, seeing, hearing, anything. It can be really anything, but there has to be a substantial limit, right, as to your ability to do whatever that activity is. And honestly, when it comes to disability, we always say, at least in my kind of office, that this is the one category anybody can become a member of at any point in time, right? By virtue of just growing older, you're going to have more problems that start to occur. And so at some point, we're all going to be in this category if we aren't already. So just kind of keep that in mind, right? As you're working with your clients. And then another way to have this category met is by having a record of an impairment. So in some situations, someone isn't currently maybe undergoing any sort of disability, right? Whether that's a mental or physical disability. But in the past they had, maybe in the past they had something some sort of PTSD, something that was really severe and prominent. There's a record about that, and somehow that's being used against them while they're trying to obtain housing. So that might come up. Another situation might be if someone has sought care through alcohol or substance abuse, but they're not currently, maybe addicted to those things. That would be a disability under the Fair Housing Act. However, there is a carve out that current illegal drug use is not going to be protected as a disability under the Fair Housing Act. So just kind of be aware of that as you're working with your clients. And then the last category when it comes to disability is being regarded as having a disability, right? And this is true whether or not you actually have a disability. And this is just based on someone else's perception of you. So someone you're interacting with in the housing context who has control over a housing unit is treating you differently because you seem to be impaired. I have personally never had this come up, but there are situations where some clients maybe they would not consider themselves disabled, but it might be clear from interacting with them that they are, or maybe they haven't had an opportunity to get diagnosed or something. And so that would be kind of what to think about as you're thinking about this category. And disability is also a special category in that it does have additional protections that we're about to talk about. But it is the one category where someone's disability can be imputed onto other people to bring a fair housing claim. And so by that, I mean, like, it's not just the disabled person in a situation in which they're the one seeking housing for themselves has a claim. It can also be if you, the caseworker, right? So maybe you're helping someone seek housing, and maybe they're not directly interacting with the leasing agent, right? Maybe you're doing that for them, but you're letting them know, hey, I'm doing this for a disabled person. They have some sort of mobility restrictions, and so they can't do the search themselves, and you're being treated differently because of that. That's a claim. But also, if there's someone in the household, so maybe it's a mother trying to obtain housing, and she mentions she has a disabled child, and she is being treated differently because of that. And so there's a claim there as well, and that's kind of the only protected category that has that kind of extra extension, I would say, or ability for it to be applied. Yeah, and so some of those additional protections that we wanted to get into, you might be familiar with from the Americans with Disability Act context, as there are accommodations that come up in that. I want to point out that fair housing and ADA, they're similar, but they're not exactly the same. So be aware they are a bit different with what they require in terms of the law. So we have reasonable accommodations and reasonable modifications. Accommodations are changes to rules, policies, procedures, or services of a housing provider that are granted at the request of a disabled person, so they are able to use and enjoy a property as much as anybody else. And this is really, once again, it's a creative process. It can be pretty broad depending on what disability a person has and what their disability related need is. I would say the most common one we're seeing right now is going to be service animals. So you might see like a no pet policy, right? But somebody has a service animal or somebody has an emotional support dog. Well, you were asking when you have that service dog or emotional support animal that you want a rule to be changed. If the rule is no dogs, we're saying, hey, please make an exception because I need this dog to be able to live, right, and enjoy my property. And these typically must be granted when they are necessary for that disabled person to be able to use and enjoy that property, but they also have to be reasonable. Some clients have had unreasonable requests in the past that just they are just not gonna cut it. And bear in mind that usually the expenses are going to be lower with an accommodation request because you're just saying, hey, change this rule or policy. And so housing providers must bear the expense of that reasonable accommodation. Some other accommodations that we see kind of typically are maybe if someone is disabled and they need to move out of an apartment, they can ask for more time because of their mobility restrictions. It's not easy for them to be able to move. Maybe they receive Social Security disability benefits and they are unable to work because of their disability. And so we're saying, hey, I know rent's due by the 5th of the month, but my client doesn't get paid, doesn't get their Social Security until the 3rd week of the month. can you please not charge them a late fee, right? So asking for that waiver of late fee. So like I said, it can be pretty broadly applied. It just kind of depends on the circumstance that your client's undergoing and what the disability is and what their need is. In a similar vein, we have a reasonable modifications, which are structural changes made to existing premises occupied or intended to be occupied by a person with a disability in order for them to have full enjoyment of the premises. And tenants must bear the cost of these modifications unless it is a federally funded property. So if the housing authority actually owns the property, that would be an example of federally funded. And the tenant's request for modification can be denied if it is if it's causing an undue burden, and if it is an administrative burden on the way the business currently runs, the way the rental organization or the property company currently does business. If it's a strain on that, but other than that, it should really be granted as long as it's reasonable. Once again, and related to the disability and has a valid disability-related need. The important part again is that nexus that we keep talking about. In this case, the nexus is between, or the connection is between, why do you need this accommodation? Why does your disability require your accommodation or your modification? Because sometimes it isn't clear. Sometimes it's very clear. And so the question then becomes, what can be asked? What can be asked by a landlord? What can be asked by another housing provider about a disability? Well, when a disability is immediately apparent by just interacting with somebody, and they've requested an accommodation or a modification, you cannot ask what that is. You cannot ask for further documentation. You can't say, hey, what's wrong with you? You can't say, how does this accommodation help you if it's obvious. And so the clearest cut example I have of that is when you have a visually impaired person and they have a seeing eye dog. Well, it's very clear from interacting with that person that they are visually impaired and they have it, and why they have a seeing eye dog. That connection is pretty clear cut. It doesn't get more clear cut than that. And so that's a clear example. Or if somebody's in a wheelchair and they have mobility restrictions, and maybe they're like, hey, I can't come to the office to pay rent. Can someone come to my home to pick up the rent? And I think that's pretty clear cut as well, right? So maybe there is some sort of restrictions there in which further verification is not needed. When a disability is not immediately apparent or easily observable, these housing providers have the right to ask, can you confirm or verify that you are a disabled person? And can you confirm or verify how this disability, how this accommodation serves your disability-related need? Because it's not apparent. What they can't do is ask you for a diagnosis. They can't ask to see your personal medical files. But they can't ask for a doctor note. They can't ask for a therapist note in which they would say, hey, yes, I treat this person. This person, they have a disability, and they don't have to get into details about that. And here is very, very broadly and generally speaking, how this accommodation request would help this person who has this disability. And that has to be very carefully done. It's sometimes hard to write those letters, but not impossible. Just keep it very broad and general. And so I kind of had like a little back and forth that I wrote down here to kind of give you an example. So let's say someone is making an accommodation request. Let's go back to modifications for a minute. I did say there's structural changes. And by structural changes, I mean like something that's being changed to the structure that you live in, so your individual unit. And most commonly, that could be things like a wheelchair ramp. That could be grab bars in the bathroom. That could be additional support, maybe in like a kitchen. It could be lowering shelves in like a kitchen if somebody has an inability to kind of reach. So it can be a lot of things, but it is a structural change to a unit. And landlords can require, and other housing providers can require that you set aside money to restore the unit to its previous, the way it previously was at the end of your tenancy, and now that would be lawful. So let's just say that, so you're requesting a wheelchair ramp, right? So requesting a modification. Know that request can be made at any time. So maybe you weren't always disabled, but maybe you are now disabled after living somewhere for 5 months, and you're like suddenly I need to make this request. Well, good news, you can make that request at any time, at any point in time. And it doesn't even have to be in a certain form. So sometimes landlords want to give you a form and say, hey, for me to honor this request, you have to fill this form out completely. And they have all kinds of things they include in there. You don't have to do that, but it can be helpful for you. It kind of, in my opinion, as a lawyer, it's good to have that physical record of what's been done. So, I mean, I'm never going to say no to someone having a form and scanning that and keeping that for my records to show a request was made, right? To show that a request was made. Was it honored? I don't know, but the request was made on this date and time. So you don't have to do that, but it's most helpful for your case, and it kind of simplifies what the request is. Sometimes landlords really don't know what the request is, or it's very unclear, so having things in writing is very helpful. Of course, if you're unable to do that, if you're unable to put it in writing, know that you don't have to. Second, you've made this request, it's out in the open. What happens next? Your housing provider is going to respond to that request. They can do a few different things. One, they might refuse the request. They might say, I don't know much about the Fair Housing Act. I don't know what this means. I'm just going to say yes, but that rarely happens. I rarely have that happen. Two, they might request more information, kind of what we talked about earlier, which is going to be, do you have a disability? Can someone verify this? And what is your disability related need? Right? And they are allowed to do that if it's not apparent, right? And the third option is they might just deny it. They might say, hey, this request isn't reasonable, or this request isn't related to a disability related need, or they might say, hey, this is going to cause me an undue burden, right, on the way that I do business. And if they do, okay, so maybe there's some valid pushback. They still have to try to work with you, and they still have to try to engage in an interactive process to determine how they might still help you, even though they can't offer you what you initially requested. So there might be some alternatives to work through. Um, yeah, and so we have our little formula, right? How do we get our modification accommodation approved while we have our disability? We have a reasonable request related to the disability, and we don't have an exception that applies. And that should equal a valid reasonable accommodation request. Yeah, and this is kind of repeating what I said earlier, but under Section 504 of the U.S. Code, federally funded properties are not required to cover the cost of reasonable modifications when the modification would cause the following, which is that undue financial and administrative burden to the provider, or the requested modification would fundamentally alter the program that's being offered. A good example of this that I've more recently come across is, so as we talked about before, there are some disabilities that might make it where someone's unable to work. And so money is hard to come by, so it's hard to pay rent, right? You might say, hey, landlord, housing provider, please accept Section 8. My reasonable accommodation request is that you accept Section 8 because I'm unable to rent, I'm unable to work, and you can probably make a very clear-cut connection, right, between like your disability and your inability to work and why you have this request. While they might say, hey, listen, I have never accepted Section 8 for anyone ever. This is going to cause me to do a lot of paperwork. I'm going to have to offer this to other people. They might have a lot of pushback on that. And the commitment of being in the Section 8 program might cause some hardship on them, right, that they haven't had to deal with before. And so that might be a valid reason to say no. You should still ask, you should still try, but that might be valid pushback. So now we're kind of shifting into our prohibited conduct, which is kind of the last aspect of our fair housing equation, our enforcement equation, right? So the first type of prohibited conduct, specifically in the Fair Housing Act, is a refusal to sell or rent after the making of a bona fide or genuine offer, or to refuse to negotiate for the sale or rental of, or otherwise make unavailable or deny a dwelling to any person because of those protected categories that we mentioned. And so that's pretty clear cut. I use that unavailable, otherwise make unavailable or deny as kind of a broad housing denial. And so just kind of bear that in mind. It's kind of a catch-all. But examples would include, not selling to somebody or renting to somebody because of their membership in a protected category. Or they won't give you information about the price of a unit, or if you have questions, they're not going to answer it, not picking up your phone calls, right? when you're calling about a certain complex, or maybe they're delaying. Maybe they're delaying tactics. They're saying, "Oh, you have to wait to talk to somebody else." Well, if that goes on for forever and you never talk to anybody else about that property, that's probably making housing unavailable to you. And then maybe the house you intended to buy that was very available is suddenly off the market after you show interest. That would be under this kind of category. And then steering, which is broadly defined as you as a person in a protected category expressing interest in a certain neighborhood, maybe in a certain house, and then you're being told that maybe somebody of your kind would be welcome or better suited for a different neighborhood or a different house, right? So a certain house or neighborhood is being made unavailable to you because of your protected category membership. Our next type of violation is the one that I see most frequently, and it is to discriminate against a person in the terms, conditions, or privileges of a seller rental dwelling or in the provision of services or facilities in connection therewith because of those protected categories. And this is really just a clear cut, somebody in the housing context is being treated differently than another person who's not in that same protected category. This could be somebody applying rules of the lease harshly or more harshly against certain protected category members and kind of overseeing or overlooking violations of another person, right? So maybe everyone's playing their music loud, but only certain people are being cited for it at a complex. Maybe someone's being charged more for rent than somebody else. Maybe there's more information required to be able to even apply for a property, and it's not being required for everybody else. So some of those background check type things we talked about earlier. Maybe there's higher credit scores, but it could also be limiting your use of the property. So maybe there are some weird rules in place. People with kids are not allowed to go to the pool after 4 p.m., right? Well, that's a familial status violation, right? You're limiting where someone can go in a place where this is an open community. Everyone should be allowed everywhere, right? And so that would be a violation. Our next violation is I call the publication kind of provision, but it is unlawful to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, religion, sex, handicap, mental status, all of our protected categories, right? And this is one that, like, once again, written for its time, you're thinking, oh, newspapers. This is about newspapers only. No, it's very broad, and so this is going to be publishing anywhere, publishing online. And even though you're not the one writing out the ad seeking to be published, if you're the one publishing that ad, you're Zillow, you're Craigslist, you're Facebook Marketplace, and there is something discriminatory in that ad, that's going to violate the section. But this will also include oral statements as well. So if you're interacting with someone and they are saying, hey, you're a nice person, but I don't rent to X protected category members. I just don't do it. That's going to violate this, right? And the cool thing about this this particular section of Fair Housing Act is even if somebody is falling within an exemption to Fair Housing Act, so maybe it's a single family homeowner who maybe owns a couple of properties, mom and pop type thing, and they're generally exempt from the Fair Housing Act. If they're doing this, if they're making a statement that's indicating a preference or a limitation, or they're using Craigslist or Facebook Marketplace to advertise a property, they're bringing themselves into the purview of the Fair Housing Act. So just kind of keep that in mind. And sometimes these ads can be really subtle. So once again, if you see like no pets, well, if it says no pets, that can be uninclusive to people who have service animals, right? So that could be a violation of the Fair Housing Act. Sometimes they might say quiet neighborhood. We seek a quiet neighborhood, and that can sometimes mean, well, no kids. But of course, I would follow up to see, what their intent is, but that can be sort of the service level intent with those. And sometimes it's more explicit sort of violations. Yeah. Our next sort of section of prohibited conduct is it is unlawful to represent to any person because of race, color, or any of our other protected categories that a dwelling is not available for inspection, sale, or rental when such dwelling is in fact still available. So this is just pretty clear cut, somebody lying, like some sort of housing provider saying, hey, no, just sold it, just rented the last one that you're looking for. Sorry, can't help you. When in actuality, like maybe someone came in 5 minutes before and they were like, oh, that's available. That you want's available. And so that does happen sometimes. So just kind of be aware of that. Yeah. The next sort of violation of the Fair Housing Act is one that I personally have never seen, and I think it's one of those historic violations, kind of trying to fight against redlining and things like that. But it shall be unlawful for profit to induce or attempt to induce any person to sell or rent any dwelling by representations regarding the entry or prospective entry into the neighborhood of a person or persons of any of our protected categories. So this is basically, I'm going to call it the white flight provision, right? Fighting against white flight. So, people are sometimes afraid of the other in a discriminatory manner. And so this is somebody who is preying on someone's discrimination, someone's racial biases and whatnot, and saying, oh my goodness, there's new people coming in here. You better get out soon. Your property value is going to go down. And they sell for like a super cheap price or something. So that is that provision. Yeah. Yeah, and so the next sort of violation we have kind of relates to real estate transactions and shall be unlawful for any person or other entity whose business includes engaging in residential real estate transactions to discriminate against any person in making available such a transaction or in the terms of or conditions of such transaction because of a protected category. And this is going to include, if you're interacting with a real estate agent and trying to buy a home or lease a home, when you're making or purchasing loans or you're seeking financial assistance, even like home improvement loans, when you're getting a house appraised, you are engaging in the selling process, you're looking for a broker. Um, and this could include things like denying a mortgage application, undervaluing your home during the appraisal process, which does happen, and creating more hoops for you to jump through to get pre-approved for a loan, and then predatory lending, such as requiring very high interest rates for people of certain protected categories. Okay, and so now we're going to what might be like my favorite provision of the Fair Housing Act. I call it the retaliation provision, but it's really quite broader. But it shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise of or enjoyment of, or on account of his having exercised or enjoyed, or on account of his having aided or encouraged any other person and the exercise or enjoyment of any right granted or protected by the sections. And those would be all the sections we just talked about, the prohibited conduct. So this is basically saying, like, if somebody's raising their Fair Housing Act rights or they're trying to exercise them, and you are literally intimidating them, trying to make them feel uncomfortable, threaten them, even filing a lawsuit against them, right, to get them to stop, there's a claim for that. And it will even apply for you as caseworkers, right? So I'm sure some of you are dealing with housing situations for your clients. Maybe you're able to spot what's happening, and maybe you're saying, "Hey, I have a disabled client," and you're treating them differently. And when you say that, if you individually start to get threats, there's a claim for you. You have a claim under this act. And so it's going to protect advocates, and this is going to also, once again, be applicable to anyone. So you don't have to own property to be violating this. You can be somebody who, you don't like that new people are coming to your neighborhood. So maybe you're putting up signs that are unkind, and maybe you are putting things in their yard. I would say like cross burning of like the early 19th, 20th century. That's going to probably violate this. You're trying to make people visibly uncomfortable, then you're violating this section of the Fair Housing Act. And I will say sometimes people don't have good fair housing claims, and sometimes we just have bad landlords being bad landlords. But even if you falsely, and not falsely, but even if you mistakenly file a Fair Housing Act complaint or something, and suddenly you are being mistreated just because you filed this complaint, this is going to be something you can bring, and you can say, well, regardless of my basis for doing this, the moment I said fair housing, this person's treatment totally shifted against me to try to make me feel uncomfortable. So that's going to come up. Yeah. Okay. And so I wanted to kind of talk a little bit about exemptions to the Fair Housing Act too, just so all of you know. But owner-occupied buildings of 4 units or less, and owners who own 3 homes or less, so our kind of mom and pop owners, they are typically not accountable for the Fair Housing Act, except for if they are kind of using a public ad or they're using a realtor to sell their home, they're bringing themselves into the purview of the act, or if they've done something retaliatory against you. So maybe they are in this exemption, but they have done something negative against someone because of a protected category membership, and that person's calling them out. That's going to be in violation of the Fair Housing Act. And also note that fair housing protections, once again, they're only applying really to people seeking to lease or obtain dwellings. And not everything's going to be a dwelling, but there's going to be some discriminatory things that happen in some of those short-term shelters and some of those motels and other places that are technically not dwellings. So kind of keep that in mind as an exemption. One second. And then we also have our other exemptions. So religious institutions that offer housing opportunities are allowed to favor their own members of their religious background. And even though that's showing a preference, it is allowed because they are a religious institution. Similar to a private club, you're allowed to discriminate, not allowed to discriminate, you're allowed to favor your membership over the general population. So you can never discriminate, but you're allowed to favor your members. So kind of keep that in mind. And then we have our housing. So you might be aware there is certain designated housing that often has federal funding for people who are 55 and up, and the other one is 62 and up. And these particular complexes, they're usually multifamily housing complexes. They are intended solely for elderly people who meet these age requirements, which means that they do not have to be accountable for that familial status provision of the Fair Housing Act. So there is an exception kind of carved in there. And then lastly, we are in Oklahoma, so this will probably be relevant, but the Fair Housing Act will not apply to tribal sponsored housing options. So just kind of keep that in mind. Yeah, and so more about COVID generally. So this is sort of fair housing and sort of not. But so how has COVID kind of changed our housing sphere? So we know there was the eviction moratorium that was in place for a while, and it came out of the CARES Act. Well, most of the CARES Act has expired, except for this one section regarding 30-day notice for covered properties. So basically, ordinarily, like if you're being evicted for non-payment of rent, you have to serve someone with a 5-day notice to quit, to pay rent or to quit, to move out. Well, this notice, if it's a covered property, says, hey, we don't want just 5 days, we want 30 days. So that can be helpful for your clients to kind of be aware of. And this is going to be for properties that are in a federal subsidy program, who have a federally backed mortgage. So Section 8, all of Section 8 programs are going to be accountable there. So just kind of keep that in mind because it can buy your clients some time if that's not being done. Yeah. So another thing I wanted to mention was COVID as both a temporary disability and as a long-term disability. So in some cases, people have really severe COVID and maybe they're hospitalized and they need certain accommodations. Maybe they can't pay rent on time because they're actually in the hospital. That might be a reasonable accommodation that needs to be granted because of the circumstances, and maybe they get better, but in that moment in time, they can't make that payment, and so it maybe can be considered a temporary disability for the purposes of the Fair Housing Act. The other thing I would say is I know that we are now out of COVID as being a national emergency as of last Thursday, but that doesn't mean that COVID's over. So you may be interacting with people who have long COVID, and they may need special accommodations or modifications as a result. And so just kind of be aware that long COVID could be a disability under the Fair Housing Act. And then, of course, when it comes to kind of our COVID era programs, we had that rental assistance, that emergency rental assistance program from the government, from the CARES Act and the American Rescue Plan, and that gave money for people to be able to pay rent that they fell behind on, or to be able to relocate if they were being evicted. And in this situation, sometimes landlords discriminated against the tenants by not accepting that rent. So maybe they would accept it from one member of one protected category, but from the another member in the same protected category, they wouldn't. And so that is cause for concern if there is some sort of disparity between the race or between color or any of that in terms of membership and acceptance of free money, essentially, for that time. So I wanted to kind of briefly talk about a couple other things, and then we'll kind of jump into questions. But I talked a lot about, what is an aggrieved person, what is a dwelling, what is a protected category, and then our fair housing violations, and then our exemptions. But now I want to talk about what it might mean for enforcement. So maybe you've done this, you've worked with a client, you've identified, and you're not getting legal advice. We don't want you to do that, but you're thinking, hey, I think they're being treated differently because of their disability or because of another protected category membership that they have. What can you do about that? So take action. But number one, you can make a HUD complaint. And HUD, Housing and Urban Development, they have a fair housing enforcement office. And they have like a few different regions all over the country. And once you can submit a short complaint to them, kind of alleging what happened in a brief way. And you can do that on the phone by calling in. You can do that on a digital form. But that will hopefully lead to like a HUD investigator investigating the concerns. This could lead to a potential settlement for your clients, to maybe get some recourse for what happened to them, or it could mean eventually that if discrimination is found to have occurred, they could possibly go before an admin law judge or a federal court judge to get compensation that way in terms of damages. So that's an option. No, that has to be done within 1 year of the last act of discrimination. And anyone can do that. You can do that for yourself. You can do that for your clients on behalf of your clients. They can do it for themselves. It's a pretty accessible tool, and it doesn't cost anything to file one of those complaints. Secondly, you can file a lawsuit within 2 years of the last incident of discrimination. So if you are outside that time limitation, you will not be able to file a lawsuit. I really only recommend that when you have, like, technically you could bring it on anything in this Fair Housing Act. But I would say to do it when it's really glaring, horrible discrimination. That's kind of makes the best cases. So if you have been evicted, if you have been denied housing, if there's been some horrible harassment, harassment is actionable under the Fair Housing Act. I want to point that out, and it is actionable not just in the sexual harassment context, while it does come up, but in all categories. So if any of our protected category members are being treated differently in terms of they're being harassed by a provider, and then keep that in mind as something as well, and that might make also for a good discrimination case in court. You could also file a complaint with the Attorney General's Office of Civil Rights Enforcement, and you can always contact an attorney for more information. And that concludes my presentation. If you need anything from me or have any questions, you can reach me at Badria Marion. I put my contact information below, and I think we have a few minutes for questions. Yeah.
Looks like we still have Lori and Stephanie on. Lori or Stephanie, do you have any questions you'd like to ask? This session is recorded, so we will send it out to everyone who attended and everyone who couldn't make it. And thank you so much, Badria, for presenting.
Thank you so much. That would be so fun. And if you come up with something later on, because I mean, I'm sure you're all dealing with different concerns for your clients, please feel free to contact me. I can answer questions at this email address. So yeah, that sounds great. Well, thank you all for coming. I really appreciate it, and I hope you got something out of the presentation.
Thank you. Bye, everyone.